Okay. Hello and welcome back to Shorr Solutions, the webinar. So you are back. If you have seen our webinars before, you know that we always have a really, really great time. We are thrilled that this week we have another special guest. So for those of you that might be new, I am Mara Shorr. I am one of the partners with Shorr Solutions, your absolute all-time favorite practice management consulting company. And my partner in crime, who is going to be your amazing host today, is none other than Jay Shorr. Jay, give a wave. Jay is the founder of Shorr Solutions, as well as my business partner. Most importantly, Jay is my father. Jay today is going to be speaking about all things legal with our amazing colleague, Allyson Avila with Gordon Rees. And Jay and Allyson are going to give a little bit more about both of their bios as well. So I am going to be going away in just a moment from the screen, but I'm going to be in the background flipping through slides. You'll see me come back at the end. If you have any questions, then please feel free to reach out to us and send along any questions you may have. But for now, I'm going to let Jay and Allyson take over. You are absolutely in great hands, and so I'm going to be going away now, but stay tuned. Jay, I'm going to let you and Allyson take over.
Bye.
Thanks, Mara.
Thank you very much. It is my pleasure to bring you to another session and series of Shorr Solutions, the webinar. My name is Jay Shorr. I am the founding partner of Shorr Solutions, which is a national practice management consulting firm. And we specialize in the operational, administrative, financial health and guidance of dermatology, aesthetic, cosmetic, facial, body, plastic, surgical practices. We get into all phases of the practice, from the practices that are first starting out, coming out of medical school, coming out of residencies, through the normal course of them practicing, all the way through the exit strategy and succession planning. And the one thing outside of human resources that I really know that every practice must need are three things. They need human resources, they need a good accountant, and they need a great attorney. And the attorney is not just for the representation of negative things. It's to ensure their compliance. It's to ensure that they don't get themselves into trouble. And it is my pleasure to introduce Allyson Avila, who is one of the partners of Gordon Rees Scully Mansukhani, a 50-state legal practice. And Allyson is one of our go-to attorneys, and I'm going to be having a discussion today and asking a series of questions. Allyson is our go-to person for contracts, for litigation questions, for legal, regulatory compliance around the country. She is based out of New York, and I'm going to allow Allyson to give a brief bio of herself before I get started. So Allyson, please welcome. Thank you for taking the time out of your busy attorney day to be my special guest. If you could just give a little bit of a brief description, a bio of yourself, we'll get started.
Thank you, both of you, Jay and Mara, for inviting me. It's my pleasure to actually be taking part in this. And I think that you gave a very good description already about what my background is. But like you said, I'm an assistant managing partner with the law firm of Gordon Rees, and we specialize all over the country in assisting clients with opening up med spas, defending litigation, defending trademark and branding cases. We do contractual work, real estate negotiations. So just about everything and anything that a client needs is something that I do, and along with my firm. So, and I started to specialize in the medical spa field because, as you know, and with physician practices, because there are so many regulatory issues that many people didn't really know anything about. And so it became the Wild West. So I started to focus my practice on ensuring that those people who wanted to start a med spa or incorporate aesthetics into their practice, or even just open up a practice, knew the regulations in order to be compliant.
Okay. If anybody has any questions during our webinar, please write them in the chat box, and then Mara will address them at the very end. So one of the questions every time we deal with a brand new client or an existing client, I always try to share that there are policies, procedures, protocols, there are employee handbooks that you should have, and they're all, they can be boilerplate, they can be similar, but they must be state compliant. And they always ask me, well, why do I need an attorney when my son took a law class in college? Now, I say that as a joke. However, it's kind of like I don't need a digital marketing company. I don't need a website company because my son took a class in college on website design and graphic design. So tell me, why do I need a lawyer in business?
Well, I can tell you my son just graduated from law school, and he knows very limited amount of information, because you actually don't really gain the experience or the information that you need in order to be able to properly advise someone unless you actually are involved in it and have the experience in order to do that. So, it's even like sometimes people just do a Google search and they think that they're getting the right answer, but you can't really confirm what that information is. But there are so many lawyers that are available that will also give information incorrectly because they're not specializing in this space. And so it really is important that you find somebody that actually is knowledgeable about the space, and so that you're getting the correct information. I'm hoping my son is going to gain this experience, especially since, during this time, it's very difficult for people to get jobs. But I would never suggest that anybody rely upon just doing a trick like an internet search or contacting somebody that just is really not within that space.
Does he know yet that he doesn't know as much as mom?
Yes,
Oh,
he does.
okay.
He will ask me questions, but it takes a certain amount of experience. I've been practicing for just about 20 years already.
Right. I guess, Allyson, you can parlay this in our industry. We deal with nothing but aesthetic and cosmetic specialists, whether they are board certified dermatologists or plastic surgeons, or they are cosmetic doctors that come out of internal medicine, family practice, whatever, and then take specialized training into cosmetics. Isn't it kind of the same with an attorney? I mean, I wouldn't necessarily ask my cardiologist to do Botox, or would I ask my cosmetic doctor to do my heart? Okay,
Right.
that's a better thing, because I think that a cardiologist could possibly take a weekend or a week course and do a better Botox than my dermatologist would be for my cardiology. As an attorney, don't you also specialize in those types of practices as well, like yourself?
Not everybody does. Some people have very limited specialties where they will only concentrate, say, on real estate, but don't have a range of knowledge or information with regard to other practice areas. And quite often what happens is, if you're going to a real estate attorney and asking them a question about how to open up a med spa, they're getting incorrect information because that person does not have that knowledge base. So although people dabble, and I think, a lot of different areas, you really need to have somebody that is focused and specializes and knows the area that is being involved.
Very important question, because it's going to lead me, I'm going to ask one question that's going to lead me into another. Explain state specifics. I mean, and we all know the answer to this, but why is it a nurse in one state can do something, and then here in Florida, a nurse cannot do it? An esthetician could do something here, and a nurse is not allowed. How is it that all these are state specific and not just general rule?
I mean, that's a difficult question to answer, but it's really just based on the various medical boards of those states and what they believe is what the necessary qualifications are for that particular person to do certain services. There's no rhyme or reason. It's the same thing here, the tri-state area between New York and New Jersey. It's a bordering state, but a nurse in New Jersey can't inject, but a nurse in New York can. So it really just has to do with, with the government process, the medical boards, and their decision making.
All right. So when we're helping a brand new practice open up their med spa or their derm or their facial, their body plastics, and the operating rooms, there's so many contracts that we have to go through. So the first thing that we do naturally is with real estate, and there's equipment. Can you just share what contracts need to be reviewed by a lawyer?
I think, realistically speaking, all contracts should be reviewed by a lawyer. They don't necessarily have to prepare the contracts. For instance, you would be preparing contracts for your clients, your consultation, your management. That's not my specialty. The contracts I would review would be after they have already been prepared, just to make sure that they're binding, that they have certain clauses in there, whether there's going to be a termination clause, or whether or not it's going to be valid and binding. Those are the things that I would look for after the contract has already been prepared. Or whether or not you're going to say, I know that you get involved in doing, letters of intent and certain lease negotiations initially, then you would want the attorney's blessing to make sure that every clause is covered. And sometimes landlord attorneys want to deal with the other, the tenant's attorney. So I would look at those contracts after the fact. And sometimes people want me to prepare a contract, say whether it's going to be an employment contract or some other contract. I could and would prepare those contracts, but it's really up to who I'm dealing with and whether they have the expertise or not. Obviously, you have the expertise, and so I don't really have to be very concerned about getting involved in any of the negotiation process, because that's not, I don't know anything about design or consulting in the manner that you do.
Right. I know that we have worked with multiple clients, in different stages of their business, whether it's in the very beginning or their specific states. I mean, I come to you all the time for questions about the state of the art of what's going on, how a contract, what should I be looking for, or I've helped negotiate a contract, and then we want to prepare that letter of intent, or they've already had a letter of intent prepared, and I look it over and I have specific questions, but I always want it memorialized, because I, as a consultant, although I have an extensive legal background, it's from the University of Hard Knocks. It's not from any accredited law school. It's from getting smacked in the face so many times that I know what to look out for negatively, but I always want it memorialized by an attorney, because in the event it has to be litigated, you want to know somebody that is going to be able to help you litigate that, also was aware of that, possibly to help prepare it so it doesn't get litigated. When should I have a lawyer review the contract? At what stage? I mean, is it after it's ready to be signed? Is it during the phase of, reviewing paragraph 3, subsection A, I, I always say that in my lectures, but when do I need Allyson? When do I call you in for the review of a contract or the preparation?
Realistically, after the letter of intent is prepared, if you're representing the landlord is the one who's going to actually prepare the lease. If you're representing the tenant, then the tenant is going to be the one that is reviewing the lease. So realistically speaking, after the lease is prepared, then I would, if on the landlord, I'm preparing it. But if I'm the tenant, I would look at it after that's already been prepared, so that then I can fine tune it, make sure that there are no clauses in there that somebody has snuck in that we were not aware of or that was not included in the letter of intent. A lot of times, letter of intent will say that there's, no personal guarantee, but then when you're taking a look at the lease itself, they then put in a personal guarantee, which most people don't want to sign off on. So, and that's where you can continue on with the negotiations and just make sure that everything that the tenant was expecting is included. Even in terms of, reviewing it for, sometimes they'll put in for like shopping centers a certain amount of hours that they want the practice to be open. And most of the time that is unrealistic. And so those are things that I would look for to make changes, because I know that clients don't want to be open Sunday through Monday from 10 a.m. to 10 p.m. So it varies. Like I said, it depends. If I'm the one who's preparing it, I'm comfortable with what I'm preparing, but as the tenant, I want to make sure that everything is looked at. Just even looking at whether or not, the rental amounts are were in the letter of intent, or whether there's an option clause to extend the lease. What are the penalties? I want to make sure that if there's a breach, what happens if there is a breach of the agreement. So there are various phases of which I would be taking a look at the lease. I can't pinpoint exactly when it's going to happen, but it should always be looked at after it's prepared.
One of the things I always say,
and before signed.
Yeah, one of the things I say often is the next time that you're going to look at that agreement usually is when you're in trouble. All right, after you blow the dust off of it, because in a perfect world, we like to think that, we're not going to have to worry about going back to that lease. I always, have come to an attorney and say, look, this is the original lease, but I'd like to know that I have options. And if I have options to renew, for example, what are the terms and conditions of that option? Because if you don't put that up front, when you want to go to renegotiate that lease option, you may be paying double because you didn't negotiate it up front, or they may have a better offer. All right. And then you're out and you've set up a perfect location. Can you explain now, I like you, I represent both sides, but not at the same time. I also represent in the purchase of a practice or a med spa, representing the doctor who is looking to purchase. I also represent the seller to determine whether or not the value of the price that they're selling the business for, whether it's multiples of gross or a multiple of EBITDA, your earnings before interest, taxes, and depreciation. I will represent whoever hires us to the best of our fiduciary relationship with them. I have been asked to represent both parties to save money. I have vehemently refused, even with a mutually signed agreement. Can you share a little bit about not using the same attorney from the buyer and the seller's perspective, the dangers behind something like that?
Yeah, well, of course, it's a conflict of interest, because if there is something that happens and there is a breach of some sort, whose side are you then going to take? You can't then represent both sides of the parties. So it's really not recommended. I mean, maybe even initially, if they're just having some initial negotiations and talking, you can talk to both sides. But when it comes down to actually formalizing an agreement, you really need to have two separate counsel. Because I've seen situations before where everything initially seems to be all well and good. And they want to use the same attorney, but then ultimately the situation goes sour, and then both sides, then there's a conflict, and then they can't use either of the attorneys that actually prepared the contract. So
I just got done, closing on a transaction in the West Coast, and what was very, very interesting is we represented the buyer. The seller was using an attorney whom I may have recommended to represent my client as the buyer. It's just that the seller ended up using that attorney to help represent them. I have used this law firm out on the West Coast in the past with other clients of ours. They happen to have recommended a colleague of theirs to represent my client. I was comfortable in the transaction only because I knew the nuances of the law firm that was representing the seller. And it was easier for me to get things done quickly because I knew what they were going to look for. Could you speak a little bit about whether or not when the representation, from my perspective, I represented the buyer, if it's a good idea to use the law firm that was suggested by the selling attorney because they couldn't represent them?
I mean, I don't see any issue with it if it's a credible, trustworthy person. I don't see that there is a conflict of any sort. It happens a lot of times too, where if somebody, I have to refer cases out to, somebody else on the other side, and they will go with that recommendation. And even though we might be colleagues or friends, or that should not ever impact your fiduciary duty and your responsibilities. So I don't really think that would create any cause of concern for me.
It did not. It worked out. I believed it worked out to our advantage because I was able to communicate, even though it had to go through the attorneys. I was able to understand what the other attorney was going to ask was the same questions that they usually ask when they represent my client on the other side. Can you explain the difference between a transaction lawyer and a litigating lawyer? Because it seems so simple. However, most people just think that a lawyer is a lawyer is a lawyer. And then I guess I'll ask you, is there really a difference in the verbiage of the lawyer versus an attorney?
No, it's synonymous. I don't know why sometimes it's referred to as lawyer, sometimes it's attorney. I mean, not that I know of anyway, unless I'm missing something.
I always felt that attorney had a more positive connotation than a lawyer.
Yeah, maybe they made up that word, yes, because you always get those lawyer jokes, right? And it's never really like the attorney joke.
Right.
But
transaction versus litigation.
So transactional is really those attorneys that are mostly office-based, mostly are just really reviewing contracts or, preparing certain agreements, more business-wise attorneys. And learning litigation is a very different skill set because you have to be able to go into court. You have to be able to have the knowledge of cross-examining somebody. You have to have the knowledge of how the court system works and what you can do and what you can't do. You have to be prepared to file motions and no. So when I first started out my career, I worked actually for the city of New York as a litigation attorney. And then my practice continued as a litigator. And then through the course of years, you also learn how to do transactions because then it became also a focus of mine. So for me, the benefit that I have is that I can do both transactional work as well as litigation. So if somebody has an issue with their contract, a lot of times, if they're using just strictly a transactional attorney, they then have to find somebody else to actually do the litigation for them. So it's, for me, it works out very well because I know what to look for in the transaction. And when it has to be litigated, then I go into court and I litigate it.
No, that's, I appreciate that. Is there a difference in, I'm not asking your personal rates, is there a difference in rates between a transaction or a litigating attorney? I know that going to court is not an inexpensive proposition, all right? Because it just seems like it never ends,
Right.
all right? Is there a difference in rate for the same attorney, that what an attorney would charge to litigate versus doing a transaction?
It depends. So a lot of times when we're doing litigation and doing defense work for whether it's a doctor or for a business, if they have insurance, the insurance company is paying the defense work. So it doesn't really come out of the pocket of the person that is litigating or is being sued. The defense rate are usually much lower than the transactional rates. And a lot of times, if you are anticipating that the litigation is going to go on for, if it has to come out of somebody's pocket, you know, for instance, like sometimes when we have employment law claims where they didn't have the proper, insurance, then you try to negotiate a better rate because you know that it's going to go on a little bit further than, say, just your 2-hour transaction. So you try to do a benefit for the clients to lessen the rates, but ordinarily transactional is a higher rate just because of the insurance.
Okay. Now, I know in our industry, we can go in and what used to be the conference where we lecture together and, you know, we have a great time. We meet a lot of people and gain a lot of clients that way. Now it's all virtual. I don't know when it will come back. I hope it's soon. But how do you handle contract issues with marketing companies, website developers, equipment manufacturers? Because every time you're going to entertain getting involved, Shore Solutions included, if you're going to hire even a consultant like us, you're going to have to sign a contract. And the contract has certain terms and conditions. They're not egregious. I will do, this is who we are, and this is what you're contracting me for, and I promise to do X and you pay Y. Mine's very, very simple because it's not worth the cost of litigation for default, because if you don't love me and we don't love you, then why work together? Mm-hmm. But when you entertain and you negotiate, Allyson, contracts which are hard, equipment manufacturer, they're hundreds of thousands of dollars. And unfortunately, in this past situation that we were in, you signed a contract, you legally owe them money. All right. It wasn't their fault there's a pandemic. All right. You signed the contract. What should you look out for as a medical practice? Now I get all these contracts, a website developer, a digital marketing company, an equipment manufacturer, and I come to Allyson. What are the most important things that you're going to help me to look out for? Because most of them are boilerplate. They don't change from one vendor to a client, you know, and then of course another vendor to a client. They're usually the same. Mm-hmm. What are the most important terms and conditions to look for?
Having a termination clause is my biggest issue with a lot of these contracts, because most of the contracts do not have a termination. So if they will obligate you to pay a certain amount of money for a particular period of time, a year, and will, like you said, will not let you out of that. So anytime that I'm negotiating one of those agreements, I make sure that there's some sort of termination clause in there. The other thing too is, you know, there has to be, the scope of work actually has to be fully outlined, and there has to be an ability to, if you're not happy with the services that are being provided, then you give them a notice of default and give them an opportunity to potentially cure that default. And if they don't, then you get out of the contract. The other thing that that happens, and it's actually just happened to a client of mine who signed a contract with a equipment manufacturer, manufacturer for about $300,000 worth of equipment. And he didn't review the agreement beforehand. And he went to trainings. He didn't know what the rules and regulations were and whether or not he could, because they think he's an ophthalmologist in a different state, whether or not he could actually use this equipment. So he didn't do his due diligence to make sure that he would be able to use the equipment, purchase it. And then of course they came after him in order to get the money, because they put in their agreements that it's up to you to know the rules and the regulations of your state. So those are the clauses that I also look for, to say it's really, you know, they can't make false promises or give false information and not put that stuff in fine print, right? Because they're relying upon the equipment manufacturer to give them correct information. And a lot of people are just not reading. You know, a lot of people are just not reading their agreements. So, and then when, like you said, when you come after the fact and then say, hey, this is what I signed, it's a lot harder to get out.
One of the questions I have is, and I have no axe to grind with equipment manufacturers. I have no axe to grind with financing companies. Nobody twisted your arm.
Right.
You signed it willingly. You had the right to seek counsel.
Mm-hmm.
And with any agreement that you sign, all right, it's always like a kind of a buyer beware. But one of the questions I have, and I've always had this question with equipment manufacturers, is when they come in and try and sell a piece of equipment, you know, even though there is a medical director and the people in that practice aren't legally allowed to operate that equipment, based on the say-so of the equipment sales rep, if not for that sales rep saying that it's okay, and you find out it's not okay, what action do you have to nullify that agreement?
Well, I mean, I'm actually in the process of doing it right now. We had to file a complaint with the court to say that the contract was signed under duress based on fraud and misrepresentation, and those are you know, the claims that you can make. You made a representation, a false representation, which I relied upon, and so you should take this equipment back, or I should not be obligated to pay you this money. So
the problem is that the deal that was made between the client medical practice for the purchase is between now them and the finance company, and the equipment manufacturer has been paid by the bank or the loan or the leasing company. So now you've got two contracts, one for the purchase and then one for the financing. So if you prevail, then what do? Do you have to get the equipment manufacturer or the distributor to pay off the loan, because there's two separate contracts now?
What happened in this one particular case is the distributor, one of the distributors actually did take back the equipment and gave a credit for $63,000, because he recognized the fact that it was made under a false representation. The other people I'm still fighting with, but you're correct. I mean, the finance companies, they want their money, and it's very difficult. You can try to negotiate sometimes, just try to lessen the amount of money that is owed. But once you sign off on that, like I said, it's not easy, and that's why those are certainly. Anytime somebody is purchasing a piece of equipment or entering into any finance deal, those agreements must be reviewed. Must be reviewed before anybody signs off.
I've been successful in many during this pandemic because I tried to get payments deferred, put on hold, and then collectively added in to either divide them by the amount of payments left at the end, or or remaining. Some were very, very amenable to that, but some of the smaller ones, the names are not important for the sake of this conversation, but some were not. and it was destructive because what happens, they actually file judgment in default.
Mhm.
They don't want the equipment back. It is a scare tactic, but they actually really put a hold and destroyed this man's credit.
Yeah.
All right. Even though, each contract stood on its own merit. I'd like to defer off of equipment manufacturers and vendors for a minute and speak about employment agreements, because as I said, the number one resource in any business is a human resource. And what are the main points that need to be clarified in an employment agreement? I will jump ahead one slide, all right, and then come back to this one and say, what is the difference between an employment agreement and an offer letter? Because on the lower end of the type of an employee, a non-contractual provider, I always write offer letters for our clients so that they're not binding. But what should be in an employment agreement? And what happens if you have to breach them because of a pandemic? What out do you have?
Well, I mean, first and foremost, obviously the parties to the agreement have to be noted. There has to be consideration that is listed in the employment agreement itself. So you want to detail whether it's going to be an hourly employee or a salary employee. You want to detail what the benefits are, whether or not there would be severance if they are terminated for any reason whatsoever. You want to have non-compete clauses in those agreements. Those are really very key, because we all know that a lot of times people will come on board, they'll learn techniques, they'll learn training, and then within 6 months they leave, and then the employer is out. You also want to have a non-solicitation clause in your employment agreements, and that is different than the non-compete, because that will say that, because in some states non-competes are just not enforceable. Non-solicitation clauses, on the other hand, are, and that dictates that the employee cannot solicit any of the patients or clients of the firm, or other employees. So those are I haven't seen any of those ever be unenforced. You want to have clauses in there that govern also what the jurisdiction is. Say you have an employee in California, and you also have one that's in Florida. You want to make sure that the forum and the jurisdiction is going to be noted in the forum and the jurisdiction that you want that case to be venued in. You want to have an intellectual property clause in there. You want to make sure that anything that is your intellectual property, any of your confidential information, is returned to you after the employee leaves. You want to make sure that the duties of the employee are spelled out in the employment agreement, so that nobody can come back and say, hey, this is not something that I was supposed to do. You want to have a termination. Sometimes, even if it's an employment agreement, it can still be at will. It does not mean that you have to keep this person on indefinitely. You could have a termination clause that says that, if you breach the agreement, you're immediately terminated. You could, have other clauses in there saying that, we'll give you 90 days, you have to give me 90 days notice so that I can, find another employee. But pretty much, I mean, I think the biggest issues are of late are the non-compete and the non-solicitation.
All right, so let me go there for a second. I see some are extremely egregious, and they're saying some of them are not enforceable. What is a reasonable and fair duration and mile radius? Because when you get into Wyoming and South Dakota, 20, 30 miles is nothing. But if you get into where I'm at here in Southern Florida or in New York or in Beverly Hills, 2 miles is big. All right. What is reasonable?
You know, each state actually has specified what the geographical distance is that they will uphold. Reasonable in terms of, you know, like you said, if you're in Manhattan, you can only do it by 3 blocks, 4 blocks, 10 miles in certain places in New York. You know, I've seen some that are up to 20 miles. And typically they will, I mean, anything above 20 really would probably be shot down, but they won't necessarily eliminate the entirety of that clause. What they would do, they would like blue line it, and then they would just decrease it to what the court thinks is reasonable under the circumstances. You know, a lot of people are saying right now, like, well, with COVID, you shouldn't be able to enforce these non-competes. But, you know, every employer is also going through the same circumstance, and they're trying to restart their business. So the non-competes should be upheld. I mean, I'm dealing with a case right now where they're complaining about the non-compete, and they're saying, well, COVID is an act of God, and so that this person should not be bound by the non-compete. And I have not, unless you have, heard that COVID is an act of God. I haven't seen that anywhere.
No, in fact, just to the contrary, on a lot of the business interruption insurance policies, it's excluded because no other primary issue took place. It was just the pandemic. You know, it could be argued either way. And of course, I see all these advertisements on TV from attorneys, and I think it's going to be a try and test.
Mm-hmm. So yeah, see what's going to be upheld. Yeah, it'll be interesting. The one case that I'm dealing with right now has a 25-mile radius. And so the biggest disagreement is because of the radius. So they want, the plaintiff wants to cut it down to 6 miles, which is for here is way too small because there, you know, I mean, there's spas all over the place, but because this particular person had so much involvement with the clientele within this particular company, 6 miles is nothing. She could essentially then just take all of the clients from this.
That brings me into another question that I do see where there are practices that have multiple offices.
Mm-hmm.
When we had our practice, we had them in dual counties. I'm here in Broward County. We had one office in the suburban Fort Lauderdale area, and then we had another one in Boca Raton, and then we had another one in Delray Beach. So it was Broward County and West Palm Beach, or Palm Beach County. My question then becomes, when you say it's X amount of miles, and I've read some contracts that we negotiate, it says from anywhere they do business. All right. Now, I do want to bring one that I had sent to you, a contract where it was a dentist. And he did literally dental work. He did teeth, and he had a non-compete. He sold his business to one of the big dental groups. But then he got into sleep apnea. And when I had sent this contract to you, you know, for review, you know, it was determined, no, you know, if he had a 2-year non-compete, it had to be where he competes. And if the dental practice that he sold to one of the big giant dental corporations does not provide sleep apnea services, it actually, they fought it. They lost. All right. Our client won. Right, because he was doing sleep apnea and the practice that he was with did not. But when your opinion was it did not, his former counsel said you could not compete. So he took it to trial where it was dismissed after your opinion came back because he had ended up getting a Florida attorney on that. So what happens when you have multiple counties when you do it and the contract says, can you prohibit somebody from doing business from any place that the corporation does business, even if you only worked in one of those offices?
I've seen it in many contracts. I haven't seen it ever be upheld or litigated at this point, but I have seen it where they will have a non-compete to say that you cannot compete within say 6 miles of any location where this company is doing business, or 10 miles where anyone is doing business, not just within that one particular office that person worked out of. So.
All right. Now I have just a couple more questions. How does a practice, this is something, you know, I've seen you on panels, on the Legal Eagle panels at different conferences. How do you best handle a situation as a medical practice when you get a negative review? We have clients that are literally, they're scared to death when they get a negative review. Many times I say, don't worry about it. It's not as bad. Sometimes it's good to have a negative review. It shows that you're real, versus having hundreds of 5-star reviews. And it's like, come on, that's not always real. Somebody has to give you a 4. But because of HIPAA breach, doesn't the patient or prospective phony patient have an advantage over the doctor because the doctor can't really call you out? How do you answer a negative review?
So, it depends on whether or not HIPAA applies. So I have the position, and some people disagree with that position, but if it's regarding aesthetic services that are not based on insurance payments, HIPAA doesn't apply. And I am of the opinion that a doctor or whoever it is that is performing the service should, at least at minimum, put in a response to say, you know, hey, we're sorry that this is the way that you feel. This is the way that our practice operates. We always try to do the right thing. You know, in this case, we believe that we did do the right thing. But I do think, and not necessarily having to say, okay, you know, X person, you know, yeah, you came in here for, you know, Botox, and we you know, gave you everything that you wanted, but you should put in a response that we strive to make all of our patients happy, and you know, something to that effect. I don't think it's good business to just let people throw things out there, because ultimately, yeah, maybe, you know, if it's like 1 or 2 and, you know, it's not horrible, you know, that would be up to the person, you know, the doctor. If they thought that it was going to really ruin their reputation, I mean, I would put in a response. It could be an innocuous response, right? You know, you're not having to name anything, but I do believe that people should protect their reputation and respond to that, because that's what people do nowadays. You know, they put these responses in the hopes that then they're going to get their money back. I mean, I see that all the time. Where
Isn't it almost like an extortion?
It is. Yeah, I mean, I think it really is. I really think it is.
Right.
And, you know, and once those things are on there, you know, like we know, like Yelp and, you know, some of these other, you know, Real Self, you know, and unless it's an extremely defamatory comment that somebody is posting, they won't take it down, and then stays on there forever. So I always say, yeah, I mean, definitely respond.
We have been successful in this last month in getting 2 comments removed because of a violation of a term of service. There were inflammatory remarks that the doctor was prejudiced. And today, you have got to be very, very careful with that word. All right. And the patient really wasn't able to say what they were prejudiced for. I have another client out on the West Coast, and they were giving out masks, all right, to people. And it was because they were giving out masks. This is in the beginning of the pandemic, so that when people traveled back out of the country, all right, pardon, something fell. When people traveled out of the country, they were able to have masks. And then another patient was upset because they weren't given masks. They were trying to say they were prejudiced against them. My final question to you is, you know, everybody thinks that they're special. What they have is better than others, and I applaud that. However, they say to me they want to, you know, every esthetician, everybody wants to come up with their own skincare line, right? Their own private label brand, things like that. What can you share, you know, in a couple minutes that we have left, that when should somebody trademark something they have to protect their brand, like so somebody doesn't steal it? Example, I'm in Southern Florida. Real big is Dr. Michael Salzhauser with Dr. Miami. Dr. Carlos Mata in Scottsdale, Arizona, he's Dr. Scottsdale. Dr. Umberto Palladino in the Fort Lauderdale area, he's the Magic Surgeon. These are handles, all right? And some of them have actually gone to ensure that they've trademarked that name. When should you and should you not worry about it? Because I've gotten involved with some trademarking issues, and I've gotten involved with franchising, and whether it is state, 50 states, worldwide, I mean, what do you do about trademarks?
It's becoming a very big issue right now because people are just not doing their due diligence before they actually even pick a name. So what happens is most people are you know, incorporating and going online. Maybe they're doing LegalZoom or just, you know, picking out a name and then creating a brand from that name. But they have not done a trademark search to make sure that that name is actually not used by somebody else already. And so now they've already invested all of this, you know, brand, your website, all of this marketing material. And then it turns out that somebody else already has that trademark. Even though the name may be available at the corporate level, it does not mean that somebody does not have a trademark on it. So what I tell people, although and doing trademark searches is very inexpensive. I tell people, before you decide to incorporate, do the trademark search first. Then you can make sure that the name is available, because that's an easy part. In fact, I just had somebody came to me that had created this beautiful logo, this website, this brand, this everything. And then she said, okay, I'm now looking to trademark this. So once we did the trademark search, it turned out, lo and behold, somebody already had a trademark. And so she's got to now scratch it. I had another client also recently, did the same thing. Created this, you know, this website, this brand without doing the search, and just got a letter saying that he was infringing on somebody's trademark. And if they don't stop immediately using the name, they would file a trademark infringement suit, which are very expensive to fight. So first thing you should do, even if you don't anticipate that you're going to have 100 different, you know, shops, the trademark search is so easy to do, and that really should be the initial step. And then you choose your information from there.
Great. I just, you know, to wrap this up, I just saw a lawsuit that was filed by Apple against this company that it's opening up a restaurant and their logo is a pear. And Apple is going against them with a cease and desist, saying that it looks too much like their logo. And what's happening is the poor restaurateur is going to have to give up because he can't afford the fight against Apple pear. I don't get it, but you know,
I don't even see how it's even.
The lawsuit was filed by Apple against them. Allyson, thank you so much. I really appreciate it. If somebody wants to get a hold of Allyson, Bob, Gordon, and Rees, Mara, if you could throw the slide up for contact information. Allyson,
Absolutely.
Your contact information as well, so that people, if they have questions, if they need an attorney, that is endorsed by Jay and Mara Shorr of Shorr Solutions. I will give a testimonial that Allyson is one of our corporate attorneys. I've used Allyson for some personal work, for some family work, and we refer to Allyson for our clients. So Allyson, give a shout out of how that somebody can get in touch with you.
Yeah, so, you can certainly contact me via email, which is listed here on the site, avila@grsm.com. Somebody can also call if they want to, 914-777-2211. And I'd like to say that I think that your company, Shorr Solutions, is just amazing. I have helped out many clients. I think that anybody who needs to open up a practice or needs a business plan or needs anything should certainly go to you. And it's a pleasure working with the both of you.
Thank you.
Thank you. Thank you so much. And for all of you out there listening, thank you so much for you listening and watching. And today, I want to make sure everybody knows that as you are listening and as you are watching, Jay and our team have requested that really we are available. So if you are looking for any of these options, whether it is a free marketing calendar, a free credit card, processing analysis, if you're looking for a patient financing registration program, we are happy to give those away as a thank you for listening and watching today. And we also would love to offer a free 30-minute consult. So I encourage you to go to the website that you see at the bottom of the screen, www.shorsolutions.com, and you will see a button for a free 30-minute consult. Absolutely no cost to you, but we really would love to get to know you and what areas are pressing around your way. So finally, if you loved this content and really can't wait to hear more from Jay, or if you thought, you know what, a couple minutes of Mara talking just isn't nearly enough, then you're able to learn and listen more with us. We love presenting knowledge. Jay will be hosting the next the next webinar. You can see that information here along with our guest, Kelly Smith of Projected Growth Consulting. You will also see that I host every week a weekly podcast called Shorr Solutions, the podcast. We get really, really creative with our names and our branding. So you can go ahead and subscribe to that wherever you listen to podcasts. Again, if you have any questions for us, then I encourage you, contact us with the information at the bottom of the screen. Social media, we'd love to hear from you, or go ahead, shoot us an email or give us a call. And that is it for today. That is all that we have for you. Thank you so much for joining us here on Shorr Solutions, the webinar. You guys did a great job. Thank you so much. You want to give a big see you.
Thank you. Thank you for having me.
Everybody stay safe during these trying times with hurricanes and pandemics. We're all in this together. We will get through it.
Yes, thank you. Thank you so much. So
Thank
with
you.
that,
Thank you guys.
thank you.
Thank you.
Bye.
Bye.